is now in session.
Thank you for agreeing to participate in this. I started to say unusual, but it's less and less unusual now. These video arguments, they'll be conducted just like they would be if you all were in a courtroom with us. It's being recorded and live streamed. If there are no questions, Mr. Hivner, would you please call the case?
The Northshore Corridor Association et al. Versus Knox County, Tennessee et al.
All right, Mr. Mullins.
Yes, Your Honor. May it please the court, I am Ben Mullins with the Knox County Bar. I represent the appellants Post Oak Bend. I'd like to reserve 5 minutes for my rebuttal. This case involves a development plan for a subdivided development of property in Knox County, Tennessee. The property is approximately 260.51 acres. The property is zoned PR, planned residential, with an allowed density of 1 to 3 dwelling units an acre. The proposed development plan sets forth 622 units, which would equate to 2.387 dwelling units an acre within the allowed density for the zoning. The planned residential zone is a planned zone, which means every development plan goes through, at least at the concept and development stage, a public hearing with the Metropolitan Planning Commission. The planned residential zone does not exclude any uses. Rather, the regulations established in this zone, I'm quoting here, are intended to provide optional methods of land development which encourage more imaginative solutions to environmental design problems. It is the county's most flexible residential zone, allowing for residential uses, commercial uses, and, quote, other uses deemed compatible with the proposed development by the Planning Commission. Now, the concept and development plan is the preliminary step in the development of any property within Knox County. And its purpose is to lay out the general density, access, and layout of the subdivision to make sure it's in accordance with the county's zoning ordinance and the subdivision regulations. Now, once the concept plan and development plan have been approved, it is subject to revision as additional expenses for engineering, stormwater, geotechnical, and other actions are undertaken for a developer to move to final plat certification. This is important to note because final plat certification doesn't go back through the public process. The concept, the final plat can change from the concept plan, but it cannot increase the magnitude of the development. But the exact density, if it's less, those things can change and be administratively approved. And that's a process for all development in Knox County, not just for this development. Now, the standard of review, this is an appeal from an action from the Board of Zoning Appeals. Metropolitan Planning Commission recommended or approved the concept plan and the development plan. The concept plan, subject to the subdivision regulations, it was not appealed. They would have to take an immediate appeal because it involves subdivision regulations to Chancery Court under a common law writ of cert. They did appeal the development plan to the Board of Zoning Appeals, as is the proper appellate procedure. The Board of Zoning Appeals heard 2-3 hours of testimony and argument from both the appellants and the appellees, and ultimately voted to uphold the decision of the Planning Commission and to deny the Northshore Corridor Association's appeal. And that's important because the standards of review for this court is essentially in the same position as the trial court. We are looking at what was in the record before the Board of Zoning Appeals when they made their determination. These zoning cases are in derogation of the common law and operate to deprive an owner of land the free use of their property, which would otherwise be lawful. So the case law tells us these laws are to be strictly construed in favor of the property owner. Additionally, the decision of a local administrative board, such as the Board of Zoning Appeals here, is presumed valid, and a heavy burden rests on the shoulders of the party challenging the local board's decision. It's this court's primary refrain from substituting its judgment of that of the local board, from reweighing the evidence of the board, or from inquiring into the intrinsic correctness of the local board. Now, there's two standards related to that overall principle that are at play here. One is the material evidence standard, and that is involving factual determinations of the local board. And if there was any evidence of a material or substantial nature in which the BZA could have, by reasoning on that evidence, arrived at its conclusions, then that decision must be upheld. That principle has been repeated since the Tennessee Supreme Court case of McAllen versus City of Memphis in 1990, all the way through the Precision Homes v. Metropolitan Government of Nashville case that this court decided in 2019. There's also a statutory interpretation here, and I want to touch on that briefly because I think that's the crux of our appeal. Regarding the interpretation of ordinances, the meaning of a zoning ordinance and its application to a particular circumstances are, in the first instance, questions for local officials to decide. Again, courts are not to substitute their judgment to reach a more preferable interpretation so long as the local board's interpretation has a reasoned basis. And in a nutshell, essentially, this is the primary mistake the trial court here made. The trial court substituted its judgment for that of the local board in regard to the statutory interpretation. It did not provide any deference to the local board's interpretation of its zoning ordinance, and it made what it believed was a more preferable interpretation without ever determining if the interpretation of the local board actually lacked a reasoned basis. And as we've briefed and as we can talk about today, the local board did have a reasoned basis for its decision. So the trial court's denial based upon its interpretation of the PR zone should be overturned. Now, beyond the issue of statutory interpretation, I raise the issue of justiciability, which is a subject matter jurisdiction question. And the reason for that is when this development was first proposed, the developer, the county, and the utility company, First Utility District, were working together on determining how can they provide sewer treatment services to this property. It was not feasible initially to run sewer lines from an existing plant owned by the utility company. So they proposed to build a wastewater treatment plant on the 260 acres that were to be developed. And that was put on the plot plan. Initially was not there. After consultation with Knox County planning staff, they reserved some property. Now the actual dimensions for that plant had not been determined because engineering had not been determined. Again, that comes later in the stage of a development. In 2019, after this case had gone through the Board of Zoning Appeals, while it was pending in the trial court, we had a lot of rain, a lot of flooding here, and First Utility District was able to procure additional funds to improve its pump stations, improve its storage tanks in the area, and actually be able to run sewer directly to the property without having an on-site wastewater treatment plant. That didn't come to my attention until after the trial court had made its decision, but I did raise it in a post-trial motion because the only reason the trial court denied this BZA approval was the trial court found the wastewater treatment plant was not proper in the PR zone. We disagree with that conclusion. However, with the ability to now provide sewer services and not have wastewater treatment on site, that issue is moot. And it is our contention that it strips this court of any live or present controversy and is an issue of subject matter jurisdiction. The appellees question I'm sorry.
Counsel, so what are you requesting of us then at this point then? If you feel that that issue is moot and that we do not have jurisdiction over this matter, what are we to do with it at this point?
Well, they have raised additional matters for appeal, and so that is before the court. However, if the court were to decide that the sewer treatment plant, as the trial court did, is the only reason to deny or to find that the BZA approval of this development plan was illegal, that issue is now off the table, and that would remove the sole impediment for moving forward with the concept plan that was otherwise approved by both the Board of Zoning Appeals and the trial court.
Would not this case have to go back from the beginning and start over, since you basically changed, these plans are basically changed completely because
And as I point out, and when the plans change, if the concept does not increase the intensity, the standard for any development is those things can be approved administratively. We're not adding additional buildings, we're not adding additional density, we're not adding additional commercial uses or wastewater treatment plant uses. What we're doing is we're removing something. And so that does not increase the impact of the development on the community. It does not increase the impact within the standards for the subdivision regulations or the zoning ordinance. And that can be approved and go forward to final plat as the normal process is for these types of developments. I know the appellees take issue with that, but again, that is the way these developments proceed day in and day out with Knox County Planning and the Planning Commission. It looks like I'm out of time. I have 5 minutes to address.
You'll get your rebuttal time, and now we'll turn the mythical podium over to Mr. Hale.
Thank you, Your Honor. May it please the court, I'm Tom Hale. I'm here on behalf of the association, the Northshore Corridor Association, that is impacted by this development in a rather large way. We all understand that the courts are not supposed to substitute their judgment on the ultimate issues in these writ of certiorari cases. But what the court is authorized to do, and the trial court was authorized to do, is to review the proceedings, the decision of the lower administrative body to see if it followed unlawful procedures, acted illegally or fraudulently in any way. I'm going to quickly, I thought I had 30 minutes, so I'm going to try to speed this thing up here a little bit. I want to get to the sewer treatment plant first and say that we cannot lose sight of the fact that it is the development plan that is being considered for approval as we think about these mootness issues. The zoning ordinance requires the submission of a development plan and what it's supposed to contain. And what it's supposed to contain, it is supposed to show, it shall show the location and intended uses of the site. And it shall be accompanied by the plot plan that is approved by the local health department. The whole idea behind this is to determine whether or not the proposed plan is in harmony with what is around it, in harmony with what the zoning ordinance says, and reasonably necessary for the convenience of the community. As best I can tell from the appellant's argument about these late filed affidavits from the executive director of the MPC and one of the employees of First Utility District, is that these MPC staff can, on their own, at their will, regardless of the procedures of the zoning ordinance, make decisions about what is contained in the plan. They act as if it's not a big deal that there's a sewage treatment plant in this development. That's part of the plan that is being approved. So the unilateral modification of the plan by the MPC staff without any formal amendment and none of the required vetting that goes along with that, it not only deprives the amended plan of the intended processes of the use on review procedures, but more than that, it actually usurps the power and authority of the planning commissioners themselves and of the BZA as well, because those are the people that the county commission entrusted with the authority to adopt plans. They didn't say the staff can modify plans. that have been submitted under the use on review procedure. So let me shift focus on the mootness question just slightly from there. This case arises out of the need for Post Oak to obtain an approval of a development plan, which it must have before it can get a building permit. It has gotten an approval at the lower tribunals of a plan that included a sewer treatment plant. It now seeks to pursue a different plan for which it has no approval. Thus, pursuant to the zoning ordinance, it will not be permitted to get a building permit. That is a controversy. That is a dispute where the administrative processes required by the zoning ordinance in order to obtain the approval of the new plan have not occurred. And the decision makers under the zoning ordinance who were supposed to approve these plans have been substituted by the MPC staff making a determination about what is appropriate to be in this plan. Judge Davis saw this as a due process issue in her decision. She was concerned about hearing these after the fact affidavits and the removal of the sewage treatment plant as being a modification of the plan, which, as she described it, it creates in my mind some due process issues with respect to the ability. I mean, as a practical matter, if you could go back and change the nature of the plan after it's already been approved or disapproved and after it's already been appealed and it's been decided, then what opportunity does anybody have to, at that point, to object, to voice any concerns? They have none, because it just becomes, for a lack of a better term, a little willy-nilly at that point. And she concluded by...
I have a question. When were the affidavits first submitted?
The affidavits were first submitted after she rendered her, as best I can recall, after she rendered her decision on the outcome of the case. Those affidavits came in an effort to get her to reconsider, to alter or amend her judgment. So they were not submitted to the MPC. They were not in the record of the BZA. They were not in the record of the trial court. They were brought about as a result of this. Once they found out what she ruled, they came up with these affidavits to say, well, the sewer treatment plant isn't going to be there anymore. And we could talk a lot about the sewer treatment plant throughout this process. We have a lot of the facts outlined in our brief that show that one time there was a sewer treatment plant, then there was not a sewer treatment plant, then you can't read the writing on the map because it's so small, to then they've decided they're going to possibly move the sewer treatment plant out of the development across Pillissippi Parkway. Now they're going to not have the plant at all. It's been a moving target the whole time we've been here. And I think those are reasons. Your question is a good one, because normally in these common law writ of certiorari cases, generally it's the contents of the record before the lower tribunal is all that is appropriate for the reviewing court to consider. And on occasion, when there are allowed additional evidence, it goes to the issue of whether or not the lower tribunal exceeded its authority or somehow acted illegally. We have found no Tennessee cases where the additional evidence was submitted after the decision was made by the reviewing court. And there's no other questions on that. I would like to switch over to the PR zone permitted uses.
Well, I have a small question. I'm a little confused about what you want us to do on this issue. Do you want us to say it's not moot because the plan has to be approved and send it back to the planning commission for reconsideration in light of the change?
What I'm proposing is that you affirm Judge Davis's ruling that the approval of a plan, this plan, because it has a sewage treatment plant, which is not a permitted use in planned residential, which I'm getting ready to get into, that illegality is the kind of illegality that will not allow the decision of the lower tribunal to stand. That is what Judge Davis held. What we're also asking the court to do is to consider our arguments on whether or not there was also illegality or inappropriateness in not following the provisions of the Knox County Farragut growth policy plan in the adoption of this development plan. That's an argument I'll get into if I have time, but that is one that the Judge Davis did not agree with, and we believe it's a substantial argument. But one of the big points that has been raised by the appellants has to do with whether or not a sewage treatment plant is a permitted use in a PR zone. Everybody involved in the case, pretty much, except the MPC staff, felt that because all the other residential zones allowed sewage treatment plants, but planned residential did not allow sewage treatment plants, they concluded that meant that the intent was that planned residential could not have sewage treatment plants within their development. That was her reasoning. Expression of one thing implies the elimination of others. That was her analysis. The appellants have implored the court to look to a different section of the permitted uses set out in the Knox County zoning ordinance. And that language is one of the permitted uses is other uses deemed compatible with the proposed development by the Planning Commission, including home occupations subject to section 4.90 home occupations. Other uses deemed compatible with the proposed development of the Planning Commission. They're saying that because the Planning Commission approved this plan with a sewage treatment plant in it, this development plan, then it must have felt it was a permitted use and was compatible. The problem with that argument is that this question of whether or not a sewage treatment plant was other uses deemed compatible with the proposed development by the Planning Commission didn't come up until it got to the Board of Zoning Appeals. So the Planning Commission never looked at that issue of compatibility. It was not, there's nothing in the record that would support any substantive consideration that this sewage treatment plant was compatible with a residential development. We've had a lot of unusual arguments in this case that have been made to justify this behemoth, huge development at the end of two little narrow roads out on the peninsula of Tools Bend. This one has got to be, to my way of seeing it, the most preposterous of all the arguments. And the reason is, do we really think that a sewage treatment plant is compatible with a residential development? I mean, I suppose what compatibility means, I think, capable of existing together in harmony. I suppose you can have a sewage treatment plant in a residential development. And this is not just a sewage treatment plant. This is a commercial sewage treatment plant that was intended to serve the entire peninsula, which includes a whole bunch more territory and a whole lot of houses that aren't currently served by sewer. out on the Tools Bend Peninsula. So it's a commercial
Let me ask you a
operation.
question, sir. Let me ask
Yes,
you a
sir.
question. Any consideration that we have regarding the sewage treatment plant and making a ruling in this case, wouldn't that only be an advisory opinion since that matter has been resolved? The sewage treatment plant is out of the picture now?
Well, Your Honor, our position on that is this. There is a plan that has been approved that has a sewage treatment plant in it. That's the issue in this case, is they can take it out and they can submit another plan and start all over again if they want to, or they can amend their plan somehow. They can take the sewage treatment out and start over again. But it's not moved from the standpoint of Post Oak Bend needs an approved development plan that is accurate in order to get a building permit. They don't have one. They've got a plan that's been approved that they're now going to try to change without going through the processes required by Knox County to change it. If they want to amend it, they probably could file some sort of amendment. And I'm about to run out of time, and I apologize. Didn't get to my other argument, but it's pretty well laid out in our brief, and it has to do with whether or not they did a broad enough study of the roadways and the traffic to include Northshore Drive.
Okay, thank you, Mr. Hale.
Thank you.
Mr. Mullins, you have 5 minutes.
Thank you. And let me start off by starting with this. The appeal to the Board of Zoning Appeals is a de novo appeal. It means that the Board of Zoning Appeals is standing completely in the shoes of the Planning Commission. It can consider everything the Planning Commission had before it and whatever additional information that the appellant or the appellee wants to present. And that is exactly what occurred here. And that's important because if I understood the appellee's argument, they were trying to, I guess, infer that since the catch-all provision, which is 5.13.02G, which he misread slightly. I want to read it exactly. It says, other uses deemed compatible with the proposed development by the Planning Commission, comma, including home occupations subject to section 4.90 home occupations. With that comma including it's not limited just to home occupations, but whatever other uses that the Planning Commission would deem appropriate. The Board of Zoning Appeals, because it's a de novo hearing, because they are standing in the shoes of the Planning Commission, they have the complete authority to interpret the zoning ordinance even differently than the Planning Commission did, come up with additional reasons why they think this is or is not appropriate. And it was at the BZA hearing that the whole issue of whether or not subsection G, this catch-all provision, was discussed, deliberated, debated, went through the entire appellate process. There was disagreement between some of the members, yes, but the ultimate vote of the BZA was to uphold the placement of a sewer treatment plant in the planned residential zone, relying upon subsection G, and that is within their authority to do so. They had a reasoned basis for that consideration. So just because that didn't come up before the Planning Commission is not an affirmity to this decision at all. The BZA had that authority and exercised it. You know, they complain that the wastewater treatment plant isn't compatible within a residential neighborhood, yet they don't want it to be removed from this residential neighborhood because that's the basis of the denial. It's also interesting to note all the other residential zones and the agricultural zone, which this property was zoned agricultural before it was changed to planned residential. The zones of the neighbors that are objecting to this use are generally agricultural, or they may be an RA or an RB, they're low density residential. A sewer treatment plant is allowed as a stand-alone use in each and every one of the zones where the objecting neighbors live. But yet they want to argue that a wastewater treatment plant is incompatible. That's you can't have that both ways. The reason it's not specifically included in a planned residential is because it is a planned residential zone. And it is, like I said, intended to encourage more imaginative solutions to environmental design problems. It has that flexibility to create a unified development where all of these uses, including commercial. I want to note the appellees keep arguing this is a commercial operation. Well, commercial uses are allowed in the planned residential zone if it's part of a planned unit development, which this is, and if it's the property is over 20 acres, which this is. But in actuality, and we talk about this as well in our brief, this is a utility use. And even though we went through the process of including this, the Planning Commission, the BZA, Knox County can't control where a utility company decides to put a use. And we set out that in our brief with the Harpeth Valley matter, which was decided in 1998, I believe. And we believe that case is exactly on point with this, where they went through the process of adhering to the zoning ordinance, was denied a building permit, and then challenged the authority of the local municipality in denying them their permit because they were a quasi-governmental utility company. So we think that is also another reason why they can't deny this development plan simply because of the inclusion of a wastewater treatment plant. There's a lot of issues in this case. Tom and I both agree that 15 minutes is not nearly enough to discuss all of these, but I believe both parties did a very thorough job outlining the issues in our briefs, and I'm available to answer any questions in the 15 seconds I have left.
We don't seem to have any other questions, so thank you both very much. Very interesting arguments. Mr. Hivner, would you please recess us until our next case?
This honorable court is now in recess until 2:30 p.m.